did a stint at Arnold as well, so he's quite pleased that yeah, very changed process. Although it had my goodies on uni, I think psychologically it was not what I wanted to do in the context of COVID. I was really struggling anyway with the unprecedentedness of it all. But I think if I'd been in a better space around managing emotions, worked a lot better. I think coming out of my degree with the COVID but it's active work, it's very fulfilling, it's so interesting. You see the whole spectrum of behavior, joy and disappointment, and disgusting. Exactly. And it's relevant to so many different aspects of kind of people's lives because a lot of them are experiencing homelessness or mental difficulties.
Here, Avison Young Ltd and
My lords, good morning. So I'm now going to turn to brief submissions on the power question before then turning at somewhat greater length to discretion. The VO's position in respect of deletion proposals on the power is no different to that described by my learned friend Mr. Mackenzie yesterday in respect to a nominal rate valuation reduction proposal. It's plainly, the VO says, within the ordinary construction of 38.7 that it can apply to a deletion proposal. Returning to that regulation, where it appears that the circumstances giving rise to an alteration, so pause, the alteration is deletion because of works to the hereditament rendering it incapable of beneficial occupation, have ceased to exist, the order may require the alteration to be made in respect of such period as appears to the VTE to reflect the duration of those circumstances.
Yep.
Now, to that, my learned friend makes two points, effectively. The first challenge is what I would call an ontological challenge, because effectively, he says, once it is deleted, it no longer exists. So you can't limit the alteration because having deleted it, it requires a new act of being brought into the list. And I have three responses to that. The first is that at the point that the tribunal is considering its discretion, this question, 38.7, the list has the hereditament in it throughout. And the ratepayer is saying, I want it deleted. And what the tribunal is considering is, okay, yes, it can be deleted from the start of the works, but we see no reason to delete it once the property is beneficially reoccupied. So we're going to limit the deletion for that period. And it really is the same point that my learned friend, Mr. Mackenzie, made yesterday. The tribunal is not inserting or reinserting the hereditament in the list as of, in this case, the 4th of October. It's already there at the 4th of October. The question that the tribunal is considering is, should we ask it to be deleted for the period 24th of June to the 3rd of October, or simply say it must be deleted from the 23rd of June with the implication that it remains deleted thereafter. So it simply doesn't work as a matter of conceptual accuracy to say that the hereditament in the list is being reinserted or having been deleted. And of course, as I say in my skeleton, the thing that's being altered is the list. It's not the building that's being altered. And the list is being altered. And the fact that the hereditament is incapable of beneficial occupation for a limited period of time allows the tribunal, quite straightforwardly within the language of 38.7, to say, well, the deletion from the list should likewise be for a commensurate period of time. The second point is that that ontological argument arises exclusively in the deletion proposal context. And yet we've heard yesterday, certainly from Mr. Wilcox, that substantively the nominal reduction and deletion proposals are the same. And the logic of my learned friend Mr. Kolinsky QC's argument is effectively that there's something special about a deletion proposal such that potentially you'd have a different answer to the question in Avison Young as to the existence of the power and the question in Great Bear. And that is plainly out of keeping with the Supreme Court's position in Monk. If we can very briefly turn back to it, and I hope also to address a point raised by my Lord Justice Arnold yesterday, paragraph 22, it's at tab 18 of the
yes.
And the tension, in my respectful submission in this paragraph, is that Lord Hodge was saying that as a matter of strict principle, if the property is incapable of beneficial occupation, it's no longer hereditament. And then he had to grapple with the fact that in Monk, of course, it was a nominal reduction case. So the proposal wasn't for deletion, it was a proposal for nominal reduction. And effectively, he says, well, I'm not too troubled by that fact that strictly speaking, this really should have been a deletion proposal because that's what follows. If there's a hereditament in the list at nominal value, that doesn't accord to my point as to whether it is a hereditament at all. And effectively he says, you know, subject to that practice is fine. He condones the administrative practice of having a nominal value. And so essentially, in my respectful submission, he is untroubled by the question of form as to whether it's deleted or has a nominal value. And that attitude must also, I respectfully submit, inform this court's consideration of the extent of the power and whether it really could be the case that it existed for a nominal reduction proposal but not for a deletion proposal.
So you agree and support what was said by the Upper Tribunal in the later case, was it the Canary Wharf case, about the sort of explaining what Lord Hodge meant in the two paragraphs?
Yes, and that's why the VO has now taken the view that strictly they fall to be deleted.
Yes, and I see you from a purist, indeed, from
Exactly.
a logical point of view, that must be right.
Exactly.
If it's not a hereditament at all, what's it doing on the list?
Exactly. And so the point is the Supreme Court basically says, well, we don't need to be too purist about this. And that's, again, my second point in respect to this ontological challenge, that that even if he were right, contrary to my first point, that somehow, at some level, the deletion from the list meant that at the end of the period there was some sort of act of reinsertion. When really talking substantively about the absence of a rating liability for the period of the works, that shouldn't result in a different approach to 38.7. My third point, I said there were 3 points, I think I probably have already made, which is that just as it doesn't follow that effectively that there is no reinsertion. The second challenge is a challenge. It's basically
Sorry.
So sorry.
I must have missed something.
Yes,
I wrote down you had
said
three
there were 3,
answers, and I've only got 2. So.
Yes, and that's right, my lord. I think in answering my first, I collated to say that there are only 2 points.
Right.
The first is that there is no reinsertion, and that's because of the historic situation. So, as one will see, I think, when Mr. Kuczynski advances his case, and obviously I have an opportunity to reply thereafter, but I anticipate that he will talk prospectively about the situation where the hereditament is deleted, and then it falls to the VO when it's capable of beneficial occupation again to insert it. And that's looking at everything prospectively. But here the tribunal is looking at it retrospectively with a list where it exists throughout, and to repeat that. But my Lord, Justice Arnold, I apologise. It was just 2 points.
Okay.
The second challenge is a different formulation, really, of the same point that Mr. Wilcox made yesterday, which is the sort of the different hereditament challenge. The argument that as a result of the works, the property becomes a new hereditament, different hereditament, with a different rateable value. The first point to note in response is that is already a qualified position from the ratepayer's main perspective, main ontological challenge, because clearly it would be allowing that, let's say in a hypothetical scenario, there was no change, there was just a period of incapability of occupation, but there was no change in the interim, that the power could arise, that they now are relying on the difference at the end. And that it has the same internal problem as my learned friend Mr. Wilcox's submissions yesterday, where he started talking about it's all about the circumstance, and it was a scintilla in time, or did it arise over the course? And then he developed it into, well, it's all about the end point, whether it's C or A. And those 2 arguments are distinct, and the second rather undermines the first. In any event, my second response to this different hereditament challenge is that it's wrong to suggest that whenever there is any valuation significant change to a hereditament, it must be considered a new or different hereditament. It's the same unit of property on a map. I've taken you to the floor plans, and there is a distinction in the floor plan of the building, but the property extended beyond the building. And you can see this point made good, I respectfully submit, in the language of the legislation. Because if you turn...
Sorry, just before we go there must presumably be a mass of law about how you identify a hereditament. And distinguish one from another, and we haven't been taken to any of that. But I imagine the position is that the degree of, so to speak, tolerance is allowed such that once you have identified a particular hereditament, then it's not every single alteration made to even the minutest bit of it.
Exactly.
That leads to the creation of a new one.
My lord, exactly. And aside from scenarios of submissions like this, there's not really an issue about it, because the issue is about its value, or if it's deleted, or if it's merged.
I mean, you've got to identify it in the first place. So there must be criteria in this. Maybe that's what you're going to take us to. But for recognizing the beast.
Yes. But here, there's no doubt that at the beginning there is a hereditament. And the question is the deletion of a part of the office on the outside, does it make it a different hereditament? And my point was only to take you, well, I'll take you to two things, if I may. As we were just at Monk, and I don't think this point's been, paragraph 5, you have the not particularly enlightening definition of what a hereditament is. And the 1988 Act refers back to the General Rate Act 1967, and that defines it as property which is or may become liable to a rate, being a unit of such property which is or would fall to be shown as a separate item in the valuation list.
It's circular.
It doesn't much assist, does it? But what I would say is effectively it is a unit of property which falls to be shown in the valuation list.
Well, thanks a lot.
Well, it was never asserted by anybody in this case, as you told us, that it was a new hereditament after these internal works.
Yes, and I think Mr. Kilinski QT will say it's a different hereditament. And the point that I wish to take you to in that same authorities bundle is, and it will suffice, I think, to go to tab 4. Sorry, I said tab 4. I meant tab 5. Sorry, tab 3, page 14. It's regulation 4, circumstances in which proposals may be made. And I mean, it's a short point. 4.1b. The rateable value shown in the list for a hereditament is inaccurate by reason of a material change of circumstances. And we know that material change of circumstances is a change to any of the paragraph 2.7 factors. So none of these circumstances are the hereditament has become a different hereditament by reason of a material change of circumstances. What it's saying is if there's been a material change of circumstances, there's been an extension, something's been deleted, you can propose that the rateable value changed. But there's no indication there that you need to treat the hereditament itself as having been different. So
there are subsequent paragraphs which G and H, which are to do with hereditaments being there that shouldn't be, or not being there that should be.
Exactly. And I suppose the point may be taken against me. Well, that's the scenario that my learned friend is saying, that actually you need to say, take out the hereditament described as this warehouse and then put in a new one that's the same, except it has a slightly different floor plan.
To keep our feet on the ground in the Great Bear.
And so, lastly, we come to a LADA, which is the main authority that my learned friend, I think, relies on in respect of his challenges. It's at tab 9. And as was explained to you yesterday, it's a case where there was a proposal that the hereditament be deleted from the list on the basis that it was incapable of beneficial use as effectively being obsolete. And you were taken to the passages about jurisdiction, because the ratepayer was arguing in the alternative that there should be a reduction in the rateable value to £90,000. and my learned friend Mr. Kalinsky relies on the discussion at paragraph 22. Sorry, 21 and 22. And the first thing to note is obviously, and I think it was noted by my lord yesterday, that where 21 starts in a case like the present cases are not like that. So there's just the factual distinction. And there's obviously no dispute that in the generality, after a deletion of an entry, the VO, absent any limitation problem, can reinsert an entry in the list, were it to be deleted by the tribunal without limitation. But again, that's not the point here. And so when in 22, we then have the passage there, where a hereditament is incapable of occupation for any purpose because of its physical state, I can see that a VO might well decide to delete the entry relating to it and not to insert another entry until it had been rendered capable of beneficial occupation. In these circumstances, it's not just the entry that is deleted from the list. It can be said that the hereditament itself has been deleted. What I would say to that is what the President was considering in this instance, as follows from the rest of the paragraph, is the difference between removal of any entry in the list for a period because it was incapable of beneficial occupation because there was no hereditament, or as he goes on, removal or adjustment of one entry to another because there's a different purpose, because effectively the alternative submission in that was that that £90,000 would be on the basis of it being, I think, storage. So you know, it's a case on different facts. And the observations being made in paragraph 22, and I can see how my learned friend derives some support from them, but they really are addressed as a different question, which is saying, if it's incapable of beneficial occupation, it can be removed from the list. But if distinct, it has some other purpose for which it could exist as a hereditament, then you could, in this language, delete the entry and enter a different entry for that different purpose.
And that's really just a way of explaining the options open to the VO in a situation where the existing beneficial occupations become impossible, but there's a possibility of some alternative. My lord, yes.
And in any event, Leda, is an authority of the Upper Tribunal, is not binding upon you. And I apologise for the slight canter of my submissions. But unless I can assist further, those are my submissions on the power.
Thank you. So then it's on to discretion.
On to discretion. And as you'll have known, that there are 5 points that we make, challenges we make. But before turning to them, I think it's just worth going to the 2 paragraphs of the Upper Tribunal in these 2 cases on discretion. I'm afraid you're going to have to go to the Avison Young bundle, tab 4, to get the Avison Young judgment. And it's page 59 of that bundle, and paragraph 40. And in this case, the Deputy President had expressed a doubt whether really he should get involved with the exercise discretion, effectively likening it to a case management decision. And in the subsequent Great Bear case, I respectfully suggested that it wasn't really a procedural sort of question of that nature, but more substantive. But that was the discussion that preceded this paragraph 40, and then he started, if it falls to me to exercise discretion afresh, which he doubts, I would do so in the same way as the Vice President. Both counsel acknowledge that because the list can no longer be altered with effect from earlier date than 1st of April 2015, it will be inaccurate however the discretion under 38(7) is exercised. The appellant will either be assessed for rates for a period on rateable value of 1.3 rather than 1.8, or it will be assessed on a rateable value of nil for the same period. The discrepancy against the ratepayer is modest but not insignificant if the power to limit the alteration only of the period of works is exercised, so if the power is exercised. But it is very significant, albeit in favour of the ratepayer, if the list remains unaltered after the reduction in rateable value to nil. I also take into account that the appellant was in a position to protect itself against the risk of this inaccuracy arising by making a proposal to enter an appropriate rateable value after the completion of the works.
So you say everything said in that paragraph is equally applicable to Great Bear?
Yes. And both those points, the problem that arises, the inaccuracy of the list, if they don't exercise the discretion, and the appellant being in a position, they're plainly material factors that have to be taken into account. And neither of them, as we see if we turn the very short treatment in the Great Bear case, were mentioned.
And your submission is it's irrational to arrive at different outcomes on essentially parallel facts.
Yes, I mean, in a sense, I could make the point in a whole sort of number of ways, absence of consideration of relevant factors or rationality, but
which one possible answer might be, well, actually, he was wrong the first time around and right the second time.
Yes, and that's I'll address you why on each point. But one of the points about the discretion, one of the reasons, in a sense, we're here before yourselves is, the valuation officer thinks that the discretion exercise in Great Bear was wrong, but also the enormous disparity in treatment in these two decisions makes it very difficult, if the power exists, to know how it's going to be exercised and what principles under which, what principles are the applicable principles for both, ratepayers and the valuation officer. So,
yes, it's a side curiosity, and we have the same deputy president of the Upper Tribunal dealing with the point in both cases, but not really giving much guidance as to how the two decisions should sit with each other in a way which is going to make them capable of application by people on the ground.
Exactly. And you'll obviously be familiar with paragraph 47 of the Upper Tribunal's decision in this case, where the only explanation of the decision is at page 70 of the Great Bear Bundle.
It's just that one paragraph, isn't it? But
It is that one paragraph.
It might be helpful if we just look back to the VTE's decision, because he effectively refers back to that, doesn't he?
Yes.
Well, they do, rather.
Yes. So the VTE decision at 93, is it 93 of the page 93 of the bundle? And paragraphs 40 to 41. And my lords, I was supposed to say that there were two operative factors in the VTE's mind. The first, that it could not be contemplated that the hereditament goes into the list at a rateable value higher than is agreed. And second, that somehow it would be the Valuation Tribunal itself that is responsible for that inaccuracy. And I think that's the basis on which the human rights concern was raised, which obviously wasn't then sort of followed in the Upper Tribunal, nor is relied upon by my learned friend. But effectively, the Valuation Tribunal is saying, well, I am going to be responsible for that inaccuracy, and because I am restoring it to the list at a wrong value. And for that reason, I'm not going to exercise the discretion. And as I'll come on to, that's wrong in two ways. First, because the tribunal is not restoring and is not responsible for the inaccuracy. And as I'll go on to, in fact, on Valuation Tribunal's case, the inaccuracy really falls outside the proposal itself and the issues that the tribunal has to consider.
Paragraph 40 appears to be the inaccuracy objection. And paragraph 41 appears to be the overcharging objection, does it not?
Exactly, but the inaccuracy is the overcharging inaccuracy. I mean, one of the things about inaccuracy is it's not a unitary idea.
No, I'm just, at the moment, I'm not seeking, as it were, to argue it out, just to identify how the VTE approached the exercise of discretion in this case.
My lord, yes.
And insofar as it gives reasons, they appear to be one, that you shouldn't exercise the discretion under 38.7 in order to achieve something that is inaccurate by definition. And number two, by paragraph 40, that it wouldn't be in the public interest and it wouldn't be human rights compliant to overcharge. Those seem to be the
lord, yes.
But if one strips out the human rights aspect of it, it appears in the end to come down to a statement that it would not be in the public interest to overcharge. And the discretionary consideration doesn't appear to have gone beyond that very, no doubt, relevant, but couldn't be said to be a complete survey of the factors that the tribunal should have taken into account before deciding how to exercise the power.
My lord, yes. And so absent there in the VTE and then again absent in the Upper Tribunal was the countervailing reason why you might exercise the discretion.
Which is the Avison approach.
Well, the reason that you might exercise it, which is that if you don't, there's going to be 2.5 years where there's something...
That's, as I say, the Avison approach, which is to balance up the consequences of exercising or not exercising.
Yes.
Not just simply saying we can't be overcharging people.
Exactly.
I mean, think of it in terms of an overcharge at all, something of a slightly dangerous oversimplification, which rather begs the question.
My lord, exactly.
Because I mean, all that happens is that the charge continues at the figure shown in the original list.
My lord, exactly.
And there can be all sorts of reasons why, during the currency of the list, the figure becomes sort of objectively wrong, but nobody does anything about it.
My lord, exactly.
But nobody would then say that nobody having done anything about it, that there was an overcharge in any objectionable sense.
My lord. And so, turning to my 5 grounds, I've already dealt with the first, which is that the Upper Tribunal omitted to weigh in the exercise of its discretion the plainly material factor in favour of the exercise, that otherwise a property which was in beneficial occupation for a very substantial period wouldn't be in the list when we say in the statutory legislation, section 42 requires that hereditament is in the list for the period where it exists. And my learned friend has a slightly circular response to that, saying, well, it's not a hereditament if it's not in the list, so there's no problem. But the reality is plainly that Regulation 38.7 power, in the circumstances of both these cases, because of the limitation question, such that the valuation officer can't alter the list now, is material. That's the only way that the list can reflect, in this Great Bear case, the fact that there was a property in beneficial occupation for a period of 2.5 years, and that must be considered, and it wasn't, and that's ground one. And that ground alone would suffice, my respectful submission, for this appeal to succeed on the discretion. Second, and points, grounds 2 to 5, all in different ways, deal with the countervailing consideration of the property being in the list already at 825,000, but in due course, the parties having agreed that the proper valuation would be 745,000. And as you'll have seen from the skeleton of the grounds, the valuation officer's second ground is that the tribunal was wrong in principle to put any weight on this discrepancy in valuation. My Lord, Lord Justice Henderson raised yesterday the question of 3810. Could not 3810 come in aid at this point to resolve the apparent problem? And I confess, I sort of rather saw things similarly, and the point was argued in the Upper Tribunal. And the resolution was that because the valuation as of the 4th of October was not a matter within the nature of the proposal, it didn't fall within the tribunal's jurisdiction to address. And the valuation officer accepts that before you. But the ratepayer can't have it both ways. They can't say, well, it's outside the jurisdiction to consider the rateable value as of the 4th of October for the purposes of making an ancillary order. But it is within your jurisdiction to consider when considering whether or not to exercise the 38.7 discretion. And perhaps I can start with the following hypothesis, namely, in this case, same proposal was made, but the parties hadn't agreed a value as of the 4th of October. So it comes before the tribunal as a deletion proposal because of the works. And the tribunal says, well, yes, I can see it was incapable of beneficial occupation for this period. But that ended on the 4th of October. And there may be an argument between you as to what the value is after that. But it's not my jurisdiction to enter into that. So that's just not a factor that figures in my analysis. I can't now go into that separate question. And there'd be nothing wrong in that situation, in that analysis, would there, with my respectful submission? The example of roadworks has been raised. There's a proposal for reduction in value because of roadworks. For whatever reason, during those roadworks, something else happens to the hereditament. There's an extension or something else. Now, no one's going to say at the point where that proposal's decided that, and the proposal's just about the roadworks, the impact on the value, that actually there needs to be an extensive look into an entirely extraneous matter to the subject matter of the proposal. And I appreciate that in some sense that's quite a high position, it's quite a purist position to take when the tribunal did have an agreement before it as to the value. But if I was wrong about that they were wrong in principle to put any weight upon it, there would still be the alternative position where it must inform how much weight to put upon it. And I'd just like to take you to two cases which I think are not the same on the facts at all, but touch slightly on the related points. And you'll have seen both in passing yesterday. The first is the York Museum's case. It's at tab 17. And I'd ask you to turn to page 25 of the decision, paragraph 110. There were many issues in this appeal, but one of them was whether the Yorkshire Museum shop was a separate hereditament or not, that the valuation officer had said it was, and the ratepayer had objected by way of a proposal which wasn't agreed. And at an earlier point in this judgment, to paragraph 55, but as you see in the first sentence of paragraph 110, the tribunal had decided that it was a separate hereditament. And then the ratepayer also said, well, we've agreed that the 7,600 that's in the list for that hereditament is excessive. And the the Upper Tribunal here says, well, that was just outside the proposal. So it was not something that they were going to look into. So here is a case where, and I appreciate it's not about the 38.7 power, but nevertheless, you have a case where the tribunal has agreed that there is a hereditament, and agreed that the consequence of that is that there is an entry of a higher value than the parties think is appropriate. But that's, to my Lord Justice Henderson's point, that's just the consequence of the nature of the proposal that was made and the absence of other proposals or changes.
May I just articulate one point, which I think is common ground, but perhaps occurs to me because of I'm more familiar with the way in which tax appeals work as opposed to rating appeals. I mean, in the tax field, it is well established that the tribunal does have a positive inquisitorial aspect to its role in the interest of the general body of taxpayers to ensure that the right solution is reached, and that can even be more than either side is sort of asking for, subject, of course, to rules of procedural fairness in making sure arguments are given, everyone has a chance to deal with arguments put forward. But my understanding is there's no equivalent to that doctrine in rating.
No, I mean, I think, and certainly, the points referred to in this same judgment yesterday, go back to the point that the jurisdiction arises from the proposal.
Yes. And that may be the answer as a matter of construction.
And so within that constraint, we have a proposal. Within that constraint, then my Lord Justice Henderson's point in respect to the tax position is probably right, which is to say, within the constraints of the proposal, that the tribunal is trying to make the most accurate result possible.
Of course, but it's limited to the to the four corners of the proposal.
Exactly, and that was my point that I started making earlier about this language of inaccuracy, because it's not a unitary thing. A list can be inaccurate in a number of ways, at a number of different times.
You say that the purpose of the tribunal's deliberations is not accuracy.
It's accuracy with regard to the proposal.
But it's not objective accuracy in terms of the ultimate outcome to achieve what the valuation officer is
Exactly. It is constrained by...
constrained accuracy. Right.
Exactly.
While we're considering these particular points, have you told us anything, or is there anything that we ought to know about how the discretion is to be exercised? What are the principles upon which the discretion is to be exercised, and has anybody said anything about that?
I don't think there's anything.
No, but
in the case of, I mean, what I would respect. I mean, my short response to that is plainly the tribunal must consider positive reasons for exercising the discretion, namely the furtherance of the accuracy of the list as it reflects the proposal. So if the proposal says, I want deletion because the hereditament is incapable of beneficial occupation, and you know that only exists for a finite period, then the exercising that power to further the accuracy in that sense is a relevant consideration that must be taken into account. The countervailing points, there may be points that it's simply not necessary because the valuation officer still has the ability to make the change. It may be superfluous because the valuation officer has already made the necessary change at the end. And then we have the question as to, well, should or to what extent other inaccuracies weigh in the balance? And I appreciate that the second ground is, on the face of it, setting a pretty high line on that, which is that if there is any agreement as to rateable value difference.
I was really asking you just about at the most basic level, what is the lodestar for the tribunal exercising the discretion under 38.7? It appears that it considered the public interest. One could think of a number of phrases such as fairness, the interests of justice, issues relating to the accuracy of the list, issues relating to alternative outcomes and so forth. Do you have any particular observations about any of those?
None of it is the subject of judicial consideration in the terms that you have described.
We'll be looking to achieve a fair and just outcome.
Exactly. And in public law terms, or it simply must take into account relevant considerations and not take into account irrelevant considerations. And further, you know, it is exercising its power in the fair determination of the proposal before it.
Right, but you say simply a bold statement as to the public interest without investigating what that actually means and what factors.
Yes, I mean,
that is not a full exercise of discretion.
Yes, exactly. That's there are, you know, to some degree the public interest doesn't really take one very much further, because in this instance there are on the appellant's case, well, my interest as a ratepayer not to pay more tax than is agreed, and on the other side the interest that if you're in rateable occupation for a period of 2.5 years, that you pay rates just as anyone else would.
And there must be one thing, isn't this right, one can spell out of the wording of 38.7 itself, because it requires, I mean, because the power is to order the termination of the period of non-beneficial occupation, whether to exercise that power must require one to do a sort of comparison of the situation if you do exercise it and if you don't. So to that extent, that must be one of the key parameters in deciding whether you should exercise this power which Parliament has conferred upon the tribunal.
Yeah,
and that inevitably requires a consideration of the amounts which will be payable and the opportunities which are available to either side to put the situation, or to alter the situation, to put it neutrally, from the end of the period if the power is exercised.
Yes, my lord, and I mean I agree in a qualified way. I mean the second ground is obviously that insofar as the countervailing consideration is the value as at the end, and that may be different to the thing that our high point argument is that that's just not, that doesn't fall within the jurisdiction of the tribunal to consider. But if I was wrong about that, and I appreciate it's a high position, but I do say, for the reasons I've already articulated, that it's a reasonable and a proper one to make, that any sort of the balancing exercises should be properly undertaken, and those are really the
doesn't
grounds.
fall away because, I mean, isn't it inevitable that if it's known that there will be a different figure, even if it's not known, as it was in this case, what the figure is, but let's suppose it's inevitable from the changes that have been made that there is going to be a reduction in the rating bill. How can it be said that that knowledge, however cohate it is, should not be taken into account in the exercise of the discretion?
I think
I understand your argument
Yeah.
that it might be fixable in another way,
Yeah.
and that will be another factor to consider in the exercise of the discretion.
Yes.
But surely the knowledge that you have a difference figure is coming up is bound to be taken into account.
I do see the force of that, and so that's maybe why I say that on ground two, the alternative position is a question of the weight to be given to the fact in conjunction with other factors, as my lord you indicate, and those other factors are really covered by grounds 3, 4, and 5. The third ground, and I'll take this very shortly, is I do apologise. If I may, I had taken you to Hughes. I said I was going to take you to 2 cases on this, and the other one, and I think maybe it would be of some assistance anyway to your lordship's point, was the Crooked Spaniard case. Which is at tab 19, which, as you'll recall, is the erstwhile pub that was then under, part of which was under a lease to someone such that it was split into 2. And if I could take you to paragraph 55 at the end. So as you may recall from yesterday, the lease that had resulted in the split into 2 hereditaments had ended on the 1st of April, and the tribunal exercised its power under 38(7) to limit that split to that period. And you see it at paragraph 55, that the appellant, the ratepayer, was arguing that should the tribunal decide that, then the rateable value thereafter shouldn't be 18,000, but should be 3,000. And I think, and I hope I'm not wrong in this, I think when Mr. Wilcox was presenting this case, he said, well, the thing that enabled the 38(7) power to be exercised in this case was that it was an ABA case. And you can see from paragraphs 55 to 57 that in respect of the appellant, I don't think, did feel it was an ABA case in that sense. But as you'll see from 57, what the Upper Tribunal said is that the proposal is not concerned with revisiting the valuation as of 2 of April 2015. So effectively it said, well, the proposal is about the division of the hereditaments, but the position thereafter isn't within the proposal. But and I'm very conscious of the time, so obviously that doesn't fall squarely on these cases, but it does again show, I think, that the tribunal is saying, well, this is the proposal. Then there may be some argument about the valuation thereafter, after the relevant period, but we're not going to sort of consider that. That's not within the proposal's scope. But to my Lord's point about, well, you know, surely the tribunal is entitled to consider the fact that there may be a difference in value after the works. Ground 3, very briefly, is that the tribunal would be wrong to consider that it was responsible for that. So this is the complaints, as you'll see in the skeleton, about the language of restoring to the list, and in some sense echoing that sense that one got from the Valuation Tribunal England's decision that it was responsible. Ground 4 is more important, and this is the fact that in the event of considering any potential inaccuracy in valuation thereafter, it is plainly a material consideration that the respondent ratepayer had been in a position to protect itself against any such inaccuracy. And we see that point made express in the Avison Young decision, and as my Lord Justice Henderson said, well, it applies the same in this. As we went through yesterday briefly at the end, and as wasn't, you know, is accepted by my learned friend, the ratepayer did have the ability, once reoccupied the hereditament, which it knew had changed in some way from the 4th of October, to say, well, it's in the list at £825,000 now. I think that's too high, and put the valuation officer on notice of that fact. It's to be noted in passing that the ratepayer in this case had the benefit of a rating agent. That's the rating agent who made the proposal in February 2015. And I note in passing that in Avison Young itself is a rating agency. So it's not that the ratepayers were, on facts of these particular cases, were somehow in ignorance of their ability separately to make a proposal to alter the valuation of the list, quite separately from any proposal they made saying, we want a deletion of a nominal value. They knew that. And that is plainly a material factor, and again, it plainly wasn't taken into consideration on the face of the decision in this case, and that again it is an error of law. That's point 4. And then, unless I can assist further on ground 4, come to the last ground, and that is really the approach, the ratio of the decision in paragraph 40. Sorry, I say paragraph, I'm looking at the wrong decision. It's paragraph 47. It is really placing decisive reliance on the fact that it had been within the power of the valuation officer to enter an accurate valuation. And the brief point, there's a conceptual point and a reality point to this. The conceptual point is that whenever the tribunal comes to 38.7, it will always be able to say, well, the valuation officer, in theory, had the power to make the alteration at the end of the list. Sorry, at the end of the period. It would apply where there is, obviously it would apply when there's no limitation issue, and where there is a limitation issue, it would apply where before the effective action was precluded by those provisions. So if that was the reason, if that was a reason not to exercise the power, it would mean that there's never a reason to exercise the 38.7 power, because you could always say the VO could have altered the list. And that's the reason why ground 5 says that effectively, take on face value, that position as really the sole consideration would render the power a nugatory one. We have the power, but in any circumstance where we might consider it to exercise it, the valuation officer at some point in the past could have made the necessary change to avoid any problem, and so we won't exercise it. The reality response is that it's sort of wholly unfair to suggest that the responsibility for the inaccuracy in the valuation list as of the 4th of October 2014 was wholly of the valuation officer's making.
I'm just trying to, I mean, we've got little enough on this point. It's 2 paragraphs in the first decision and 1 paragraph in the second decision. But the UT picks up the submission of Mr. Kalinsky, which is to do with the valuation officer having missed the chance to make the change. But that doesn't seem to be the point that came from our examination of the 2 paragraphs in the VTE decision. Or
I think, yes, I mean, yeah, I don't think I have a full answer to that. I think what they're saying is the VTE was right not to make an order,
yes,
but then give their own reasons for why the VTE wasn't right.
Yes, but I mean, are we concerned here with the discretion exercised by the VTE?
No. No, and apologies, I should have made that clearer earlier, that we are dealing with the exercise of the Upper Tribunal, which had the power to make any decision that the VTE was in a position to make.
But is that right? Because it's an exercise of discretion. The discretion is conferred by statute on the VTE, not on the Upper Tribunal. So therefore, surely the question is whether the VTE properly exercised its discretion. If it properly exercised its discretion, then neither the Upper Tribunal nor this court is entitled to interfere.
My Lord, one of the features of Lands Tribunal jurisdiction, the Upper Tribunal Lands Chamber, is that effectively hearings before it are de novo hearings. So they...
Well, I appreciate that, but it's not conferred, given a fresh discretion in the absence of any error in the VTE's exercise of its discretion, is it?
Well, I respectfully, the provision. Sorry, apologies. The provision in the regulations is 42(5).
Just before we get into the
So sorry.
regulations, are you therefore submitting that in the Avison Young case, the Upper Tribunal was wrong to ask itself, firstly, whether the VT had exercised its discretion correctly, and only to consider its own exercise of discretion on the hypothesis that the VT was wrong? You seem to be saying that it ought to have simply have said, well, never mind what the VTE decided, I'm going to re-decide the matter myself.
I'd respectfully say it would be open, and maybe I'll have to take instructions and return so I don't speak incorrectly on this, but the Upper Tribunal is hearing the substantive matter afresh, and that the regulation 42(5) allows it to confirm, vary, set aside, revoke or remit the decision order and make any order the VTE could have made. So the statutory scenario is that the Upper Tribunal is able to make any order the VTE could have made.
That doesn't really answer the question. Does it? I mean, one gets that provision in all sorts of contexts, where an appeal is simply by way of review, and it just goes to the remedies, which can be deployed if the lower tribunal is found to have erred. As I understand it, what you're saying is that the statutory scheme here is one whereby the appeal to the Upper Tribunal proceeds effectively as a complete rehearing.
Exactly,
And
it's
also
not on an
it's
error
possible
of law.
to adduce fresh evidence and so on and
Exactly.
so forth.
And it's not only on an error of law, so it's not where there's been a, you say, well,
I mean,
we're
it's
only
like-
going to interfere with the discretion if there's been some error in law in its exercise.
It's like appeals to a judge in chambers, and some of us were much younger than we are now.
So if we look at paragraph 47, you say that that is the correct target for your submissions,
Yes.
and forget the two paragraphs of the VTE. We appear to have two slightly different reasons given by the UT, which is significant inaccuracy when it had been in the power of the valuation officer to enter an accurate valuation. So that's the reason given by the UT, and that's the size of it.
Yes.
Right, and you say just as the VTE's exercise of discretion was inadequate, so is that.
Yes. And the fifth ground is really about the sole reliance, it seems, upon the notion that it was within the valuation officer's power to...
Very sorry, but
I'm sorry,
your
sorry.
submissions just now seem to be flat contrary to what you say in your skeleton argument. I'm looking at paragraph 14 of your skeleton argument.
My lord, yes.
Where you say, oh, I'm sorry, I'm confusing the appeal to this court. So, yes, all right. So 14 is talking about the appeal to this court.
Yes, and so in effect, this court has the powers that the tribunal could have made, and the tribunal could have made and done anything that the VTE below it could have made, could have done.
Is there nothing else about appeals to the Upper Tribunal other than Regulation 42.5? Is that the only relevant provision?
I think I read somewhere a recent judgment of this court explaining the situation, and I forget where I came across that, but But effectively, I think saying what I was putting to you,
Yes, exactly.
It is a complete re-hearing in this court. In the Upper Tribunal.
My lord, yes, and I feel that there is one of the decisions before you in the bundle does talk about the de novo nature of an upper tribunal hearing. I'm conscious of the time. It may be that I can assist better
Maybe Mr.
having a moment.
Put us right on this.
But you know, those are the submissions, and,
Yes.
and as my lords, you will recognise what the valuation officer asks for, the appellant asks for, is either that you exercise the discretion yourself in it,
Yes.
pursuant to that power, or you remit it with guidance.
With guidance.
On my lord.
Thank you very much. So, yes, Mr. Walensky.
No, please, your lordships. I'm conscious I've got a fair amount of ground to cover and want to do my best to deal with the points that are troubling the court and not to repeat matters that obviously are already understood. So that's what I'm endeavouring to do, and no doubt I'll be corrected if I stray from what an appropriate balance is in that regard. I was going to start very briefly with the facts. The court obviously understands the proposal that was put forward and the context in which the proposal was put forward. The critical starting point is what's the statutory ground for that proposal. It's a deletion under Regulation 4(1)H to delete the hereditament from the list. I hope it's helpful and not taking matters too shortly to just use as a sort of working step of analysis paragraph 36 of my skeleton. Now, with the caveat that I accept that this is a prospective analysis, and I'll have to come back to the point made against me that there's a change and that Regulation 38(7) is retrospective and that that's something of consequence. But in terms of working through the decision-making chain that the proposal gives rise to, I hope it might be helpful to start at paragraph 36 of my skeleton, page 43 of the bundle.
Thank you.
So there's a statutory question about whether the proposal is well-founded. It's saying it should be deleted in essence because of the works rendering it incapable of beneficial occupation. So the first point is on the correct legal understanding that we now have, that proposal was well-founded. And what does it require? Well, that's unambiguous. It requires the deletion of the hereditament from the list. And for the purposes, we're not troubled by the fact that it sought the 16th of June as the effective and material day, because it's common ground that the 23rd of June 2014 is the material and effective day, and that's the effective regulations that you haven't been troubled with, but that's common ground, and it's the colour wedding case. So we know that the entry should be deleted from the list on that day. Whose role is it to give effect to a well-founded proposal? Well, as Mr. Wilcox shows you, Regulation 10 makes it mandatory for the valuation officer to give effect to a well-founded proposal, and that's initially their role. And we know that the Valuation Tribunal and subsequently the Upper Tribunal stand in their shoes so far as the determination is, subject, of course, to the discussion of Regulation 38(7) that I will come to. So then it is common ground in the light of Monk that there's no basis for there being any hereditament in the rating list from the 23rd of June to the 3rd of October 2014. Nobody's contending otherwise. So then in the ordinary course of events, how does the hereditament get back in the rating list? Well, in the prospective analysis, it's absolutely clear. The proposal communicates the need for deletion to the valuation officer. The valuation officer grapples with that, accepts that it's well-founded, deletes it, and then puts a new entry in the rating list at the point at which the property becomes capable of beneficial occupation. Now, in the ordinary course of events, that is a new entry, which section 42 subsection 4 requires the ascribing of a rateable value to, and under the regulations, therefore, an entry is made, a rateable value is assigned, and importantly, a right of appeal arises from the date of that alteration in relation to the rateable value for 6 months, even if that's in the twilight limitation period that the valuation officer gets. So it's 6 months from an alteration. So there's a procedural right of reply to that new entry and the rateable value ascribed to it. And the vice of using regulation 38.7, I say, is that it takes that away. And I'll show you it's absolutely unequivocal that it's taken away on the face of the regulations. My submission will be that must go to the scope of 38.7, or if I'm wrong about that, to the approach to discretion.
What is a ratepayer deprived of in comparison with the process that starts off with 42.4 as against the process that would follow the ratepayer making its own proposal?
A prospective proposal.
Yes.
So I appreciate that.
As I understand it, what does it matter whether the valuation officer starts the ball rolling or whether the ratepayer starts the ball rolling by proposal?
Well, my answer to that, my lord, is is many and various. But let me try and assist my lord directly with that. So I will be saying, and I'll show my lord it, that it's absolutely unequivocally a feature of the scheme that the valuation officer maintains the list. That it's a feature of the scheme that the ratepayer makes a proposal and the valuation officer responds to that proposal. So the ratepayer has put in issue the entry in the hereditament from June 2014. That the scheme, and Leader Properties in particular, interpreting the scheme, makes it clear that that throws the ball, if you like, into the valuation officer's court to grapple. And if the valuation officer grappled with it in time and on a correct legal understanding, they would have taken it out and then put it back in on the 4th of October.
Yes, but my question was a different one, which is, you're referring to the protections that arise from the scheme operating in the first way. I just wanted to understand whether any of those are lacking if the scheme was operated in the second way.
And forgive me, the second way is the ratepayer anticipating...
Yes, because the ratepayer is presumably knows that when they start using the property beneficially again, they're going to have to pay rates. So why are they... I mean, I could understand if you said, well, it's only the scheme whereby the valuation officer puts in a new entry, or however one describes it, that offers me these protections. If that's the case, I'd want to understand what the protections are that are offered, which are not available if the ratepayer makes a proposal.
And the submission is predicated on the legal proposition that the scheme expects the valuation officer to lead and the ratepayer to respond.
Well,
is the
answer then that there are no protections that are lost?
No, well, my lord, no, I don't accept that. But I will try my best to directly answer the question. But I don't accept that proposition. So on these facts, I do concede, in the interest of being fair, that it would be possible to anticipate and proactively make a proposal. There would be a degree of jeopardy in guessing the date, but my lord can reasonably say that's a discoverable fact. And I certainly don't say the ratepayer was unable to make a proactive proposal. But what I do very much say, and I do say is of importance when one understands the scheme, is that there was no expectation or requirement for the ratepayer to do that. If the scheme works as the scheme is anticipated to work, there will be an opportunity later down the line to respond to the entry that the valuation officer makes, having considered this proposal.
So your submission is that the ratepayer is under no duty whatsoever to ensure the accuracy of the list, and is entitled to take advantage of any inaccuracy which arises thereafter, which the VO is unable to correct.
So as to the first part of that proposition, my lord, absolutely yes, that is my submission. Now, if the court was designing the rating scheme for itself, no doubt it wouldn't. It would have an element of self-reporting, an element of self-assessment, and there's currently a debate through Parliament about, does the rating system need changing? And with effect from the 1st of April 2017, which we're not troubled with those, there's a greater degree of reporting, a check stage, greater degree of evidence. But the scheme absolutely is the valuation officer leads, the ratepayer responds, and the nature of the response is absolutely defined by the proposal. So as to my Lord Justice Jackson's perfectly understandable question, I cannot say the ratepayer couldn't have anticipated this, but I absolutely can and do say the ratepayer didn't need to anticipate this because the scheme supposes the valuation officer maintains the list, and had they done that within the limitation period, there absolutely would have been the ability to make a proposal challenging the rateable value if the valuation officer got the rateable value wrong. If the valuation officer got the rateable value right, there wouldn't be the need for any such proposal. So my Lord, I don't accept the force of the point that the ratepayer could magically have foreseen this and been proactive. It might be right factually, but it's not sensitive to the true nature of the legal context. And so therefore, the force of that point, which I appreciate was at the forefront of the Upper Tribunal's consideration in Avison Young, but actually I'd respectfully say, having perhaps reflected on it and looked at the different facts of Great Bear, where the error on the part of the valuation officer is much starker, because my lords are obviously concerned about the, if you like, close to £1 million of potential rates that drifts out of the process. Well, 2 years of that is unequivocally due to the failure of the valuation officer to give effect to the Supreme Court's decision in Monk and make an entry when the law was absolutely clear. So that was what troubled the Upper Tribunal. I will be saying justifiably it's a completely different set of facts from Avison Young, and the error is stark, and the greater loss to the hypothetical loss to the public purse, because on a correct analysis there's no loss to the public purse unless and until there's an entry in the rating list for the period in question, because the whole of the liability is predicated on the existence of hereditament. But that notional loss, the 2 years of the 2.5, is absolutely attributable to the fact that VO didn't do what they could have done for a year after the judgment of the Supreme Court in Monk, which came out on the 1st of March 2017, and the window for the VO closed on the 31st of March 2018. And those are the dates that are agreed in paragraph 38 of my skeleton. So my lords, I've slightly gone out. Can I go back to 36 just to finish off? I say at 36F, it was the role of the valuation officer to make that entry, and I give the times for when that's been forwarded. I think I've covered that. So may I then just go to the points on the scheme itself, and again, to try and take it shortly, if I work from my skeleton argument as much as I can. So I've tried to collect together some points on the statutory scheme in part C of my skeleton, starting on page 39, from paragraph 13 onwards. Now, I'm grateful to Mr. Wilcox for his careful and comprehensive coverage of much of this, so I'm not going to repeat points he's already taken. So, for example, the first point, the daily tax point, is the court will have in mind. The court will obviously have in mind the New Biggin and Canary Wharf. My second point, and I've just made the submission. That's the third point about this is a slightly unusual and technical scheme. You don't get liability unless and until you've got a subsisting entry for the day in question in the rating list. And if you haven't, you miss the limitation, it's actually incorrect to say that there's a liability that's not paid. There's just a missed opportunity to do a preliminary step that's necessary for a liability to be incurred under the scheme. And that's section 43 and 45 that my learned friend Mr. Wilcox has already showed you. So the meat of the issue and the focus of my answer to my Lord Justice Jackson's concern that the ratepayer failed to protect themselves is my points 4, 5 and 6. So point 4 is that on making an entry in the rating list, the only matter that can be done when you make a new entry is you attribute a rateable value to it, and that rateable value has to be a rateable value that's consistent with Schedule 6. And in the footnote, I refer to a couple of cases that are rateable value cases, but they're in the context of material change of circumstances, where the tribunal emphasises there's no statutory basis for valuing other than in accordance with Schedule 6. I accept if you have something before you that doesn't allow you to value, you can keep in an entry that's not consistent with Schedule 6. But my submission is that in substance here you would be reinstating an entry, and that would actually be inconsistent with that feature of the statutory scheme. I will come back to that in just a moment. My fifth point is the one that I've already emphasised, which is absolutely common ground that the duty is on the valuation officer to compile and maintain. That is a seminal feature of the statutory scheme. And I just draw attention to the Baird case. Facts of Baird were very different, but what they show is that the duty sits alongside and yields to relevant limitation periods. So the duty isn't a freestanding duty of accuracy. If you lost the opportunity, they hadn't on the facts of Baird, but if you had lost the opportunity to make changes, then you can't rely on the general duty of accuracy because it subsists within a statutory scheme that includes Section 55 and the regulations made thereunder. And then 6 is the point I've tried to articulate in exchange with my Lord, Lord Justice Jackson, about the essential...
You say there that their role of the ratepayer is essentially reactive.
Yes.
Well, except if it's in their interest to be active.
Well,
you might more fully say, because it wasn't reactive in either of the cases before us when the building was not occupiable. The ratepayer became highly active, either seeking nominal or seeking removal.
I think, my Lord, I certainly there are opportunities, but even then, what my Lord is characterising as proactive, in fact, it's reactive, because what are they? They're making a proposal that's active, but what are they making a proposal in relation to? They're making a proposal in relation to the list as it exists on a relevant day. That's what they're doing under the statute. So back to my learned friend Mr. Wilcox's analysis, but plugging it into my case. So in my case, the particular proposal we made related to June 2014, take it out of the list. That was the issue. This shouldn't be in the list. Now, it was right, and only right, for a limited period, but the proposal defined the dispute. It was the ratepayer's work was done in making that proposal. Nobody claims it's an improper...
I'm sorry, I know we're going over old ground again, you've got a lot of ground to cover, but it can't seriously be said, can it, that it's Parliament's intention that the ratepayer's position can be met only in circumstances which favours the ratepayer. The ratepayer knew perfectly well that it was going to become active again, that it was going to become beneficially occupiable again. That was the whole point of doing the work, was to make it appropriate for its beneficial occupation.
Yes.
And so at the point that it then becomes subject to beneficial occupation, the ratepayer has the same scope for activity as it had when it wanted a reduction.
But because of the nature of the proposal that was made, take it out of the list. That put in issue, I say, subject obviously to the powers at issue in these proceedings, but that put in issue the position at that date and on every date thereafter, and what it
But
did...
that's not right, is it? Because the proposal was not to demolish the building. If the nature of the proposal was this should be taken out of the list permanently because we're knocking down the building, there's going to be nothing to rate hereafter, then it would be a different ballgame. But the nature of the proposal in these cases was inherently temporary. This was refurbishment or reconstruction, whatever you care to call it. So it was inherently a temporary proposal.
My Lord, I can't argue against that. And my learned friend fairly indicated that the reference to permanent demolition was probably a default, and read it together, it obviously refers to building work. So I absolutely don't submit to the contrary. What I do say is you need to go from that generality to the particularity of the statute. So what was the statutory issue raised by that proposal? I say it was take this out of the list from the 23rd of June, when you read it together with the known circumstances, June 2014. Take it out of this. That was the extent of the statutory issue raised. Now, I accept, absolutely, that is an incomplete analysis, but I do say that's a sufficient action on the part of the ratepayer to raise the issue. That passes the responsibility for responding to that proposal under the statute to the valuation officer. Reg 10 makes that absolutely clear. They have to ask themselves, is this well-founded? If it's not well-founded, it goes to the VTE. So upon receipt of that, there's a contestation.
But this is all massively artificial in circumstances where by the time it gets to the VTE, everybody knows what's happened. This is all past events. This is not some speculation as to what's going to happen in the future. By the time it gets to the VTE, everybody knows the refurbishment has been completed, the property has been, beneficial occupation of the property has been resumed. And the only question is, what do you do in respect of the period when it was not capable of beneficial occupation?
Well, that's not the question raised by the proposal. The question raised by the proposal was, should there be a hereditament in the rating list on the 23rd of June 2014? Full stop. The answer to that was no, and that then required some action from somebody to put a hereditament, new or reconstituted, or however one might want to describe it, into the rating list afterwards. That's my submission. And that submission...
It was already in the list.
It
didn't need to be put back in. It was already there.
Well, as a matter of substance, it absolutely comes out on every...
Because conceptually, this is a list which exists on each day.
Yes.
And therefore, throughout the period from 1st April 2010 to 30th, 1st of March 2017, you have a list which exists from day to day.
I certainly accept that, yes.
And so, therefore, when you say, well, take it out of the list as at one date, inherently one is therefore concerned with what is the temporal extent of the alteration of the list.
Well, my Lord, my understanding of the valuation officer's case is that it's expressly conceded that you can't put this hereditament, they can't put this hereditament back in the list pursuant to the proposal. So that's why we're in the Reg 38.7 argument. So that rather chimes against the proposition that my Lord's putting to me, that it's inherent in the nature of this proposal that it was always temporary. Because if that's right, then if you put it back in, you would be giving effect to the proposal and you wouldn't have a limitation problem. But we're here because the valuation officer positively says, I have no powers because my limitation period has finished, and it's implicit in that they are accepting that you cannot put this back in the list, giving effect to the proposal. And that's the whole basis on which this issue arises. So, my Lord, that rather goes against the exchange that we've had, not the submissions I've made, but the propositions that my Lord's putting to me, that it's inherent in the proposal. Were that to be right, the issue might not arise in the way that it does in this case. I hope my Lord understands the submission I'm making in relation to that. You've seen my 6 points on the face of the statutes, but can I just I was going to go to leader, but I'm conscious you've seen leader twice. But my submission on leader is not our facts are analogous to leader, but leader gives you the authoritative analysis consistent with the submissions I've just made of the responsive nature of effectively the statutory dialogue between a ratepayer and and the valuation officer. The proposal, quite technically, defines the nature of the dispute. The valuation officer in a deletion proposal that he considers is well founded, takes out of the list, and then has a further decision to make. And then my submission is the statutory scheme allows that to be put back in a rateable value, giving rise to the opportunity to challenge. So I won't take time on leader, but I do. It's in my skeleton. I do say paras 19 to 23 of leader are absolutely consistent with the submissions I've made about the nature of the scheme. I do want to show, my lords, a feature of the scheme that you haven't yet seen, but which does underpin my submissions. So if we could go to the list and alterations regulations of 2009, which is, if the court would go within tab 3, and go to regulation 4 first of all. Is my lord there electronically? I'm grateful. Mr. Wilcox showed you this, but I just want to show you the difference this makes. So Mr. Wilcox showed you regulation 4 1B. He mentioned D and he mentioned H. So we're a H case. He's a B case. Nobody's a D case. Okay, what is a D case? Well, a D case is that right of reaction. Okay, there is an ability to propose a challenge to the rateable value of a hereditament shown as a result of an alteration. So on the right analysis of the valuation officer doing its statutory duty, on my case, it receives my proposal, it goes and investigates at whatever moment it does, and it decides that it needs to make an entry. And there's some jeopardy as to whether they could do that before the closure of the relevant bit of the list up to the 1st of April 2015. But there's absolutely no jeopardy for the period from the 1st of April 2015 to the 31st of March 2017. At that point, they make a new entry, attribute a rateable value. If it's 745, we don't have a problem. If it's 825, we have a right of challenge. That right of a challenge, see section 5, regulation 5(2)A, goes from 6 months after the alteration or the closure of the list, importantly, whichever is later. So it survives all the shenanigans about the limitation periods. It's a statutory entitlement. So that's the position if the valuation officer acts in accordance with their statutory duty. What's the position if the valuation tribunal makes an alteration or directs an alteration? Importantly, if you go to if you go back up the same page and you see regulation 4 subsection 3, and you've seen a bit of this but not the critical bit, no proposal may be made, and then C, on the ground set out in 1D, that's the alteration ground that I'm concerned with, to the extent that the alteration in question gives effect to the decision of a valuation tribunal, the VTE, Lands Tribunal, or Upper Tribunal, or a court determining an appeal on an application for review in relation to the hereditament concerned. So the point is, it's not just a sort of bold assertion we wouldn't have a right of appeal. There's a statutory foreclosing of a right of appeal. So if the tribunal directs the list to remain in a state that is inaccurate, that's closed off automatically under the regulations. Now, my submission on that is that's a powerful indicator in favour of Mr. Wilcox's argument, certainly applied to my case, that you shouldn't be thinking about Reg 38(7) in an A, B, C context as opposed to an ABA, because if the rateable value of the before and after situation is different, there's a statutory foreclosure of having any remedy. And subject to my Lord Justice Jackson's point that, well, we should have foreseen that and acted promptly, I've addressed that. But if I'm right in answer to that point, then there's a real jeopardy arising from the valuation tribunal making an entry which is known to be wrong and which the statute forecloses a challenge to. And that must go to discretion, but I actually submit it goes to the prior question of how one thinks about that power, and Mr. Wilcox's submissions that power is much better understood in the context of a reversion to status quo ante, as he puts it, the ABA situation rather than the ABC. That makes a sense of the rights and responsibilities and remedies cooked into the overall statutory scheme. So those are the points on the statutory scheme. May I then offer some observations on the purpose of the Regulation 8(7) power? And consistent with the discussion that the court had with the advocates yesterday, this is a slightly puzzling situation where this power seems to have existed for a very long time and has suddenly become front and centre. Well, and it's potentially quite an unremarkable power on its face, but why is it being thrust into prominence? It's being thrust into prominence because of the claimed solution that it offers to circumvent limitation periods. And my submission is that's inherently problematic in itself, but actually all the more so given that where the Valuation Tribunal actually is directing the entry, there's no right to come back on that under the statutory scheme. So I adopt the submission that my learned friend Mr. Wilcox made, that the right way to think about this is that the general rule is Regulation 8(4). It's a date-specific determination on the basis of the proposal, and as to Regulation 38(7), that should be handled with care insofar as it offers an invitation for a wide discretion or for a wide power to effectively treat as a reversion to a situation a process of adaptation and changing something from one thing to another. My submission is that's not what's being contemplated either on the face of the words and specifically on the place of the words read together with the limitations that arise where the tribunal exercises its power. So my submission is this is a limited tool to make the list accurate when it is both efficient and fair to do so. And the roadwork case, where nothing changes in the before and after, is no doubt a situation where it would be fair and sensible to do so. But my Lord Justice Arnold was contemplating, we've got to make sense of this, my Lords, I think, as a whole were contemplating, we've got to make sense of this absent the limitation period. Well, if you go back to the point I've just made about every time the tribunal directs an alteration, you don't have a power, that would support the proposition that one would have to handle very carefully, even absent a limitation period, utilising this power where the rateable value is known to have changed from the pre-existing situation. Certainly in these type of cases, these monk cases, where the whole nature of what's proposed is comes out of the list.
How does one know that the rateable value has changed if one views the entire exercise wholly prospectively?
Wholly prospectively?
Yes.
Well, on these facts or more generally?
Just generally. Because you're arguing forcibly that we look at this prospectively as at the date the ratepayer makes the proposal to take the hereditament out of the list. Now, viewed exclusively as at that date, you know nothing about any future change in the rateable value. So you can't assume that the rateable value will be changed one iota.
Well, I'm not sure that my submission about the limitations of the power on the tribunal depends upon it being prospective. The point I say is prospective is judging the opportunities available. At the point at which the tribunal is thinking about exercising its power, I do say that in substance it would be basically taking out and then putting back in. I absolutely do say that. But in answer to my Lord's question, on the facts of Great Bear, one does know actually, because the building works had been completed when the proposal was made. So you actually do know on the facts of Great Bear. There will be cases where you don't know. I accept that, but where the composition of the property is changed, or there's objectively ascertainable facts that it is planned to change, then you will know. So in a typical monk style situation, you will know, although against myself I would concede that in the Canary Wharf scenario, where the strip out occurred and the scheme of works for reconstruction wasn't yet crystallised, but it was known that there was going to be one, you wouldn't know absolutely for sure. But my submission is that when the tribunal comes to think about Regulation 38.7, if it does know, that's a really important indicator against the existence of the power, and certainly in terms of the exercise of discretion. Does that at least offer some kind of attempt to answer my Lord's observation?
I think it'll do for now, thank you.
Thank you. So those are my observations in relation to Regulation 38.7. So in terms of where that goes in the scheme of the case, obviously I've served a respondent's notice in Great Bear, so my submissions on that align with Mr. Wilcox's submissions in relation to Avison Young. I say in my case, the power properly understood shouldn't be available, effectively because the power contemplates the situation, the ABA situation, the status quo ante situation, rather than the planned alteration to, on my facts, both the footprint and necessarily the valuation of what results from what I say is an intervention of the completion of the works and the property becoming capable of beneficial occupation. I say that doesn't fit with the language and also approached purposively in terms of the rights and remedies under the scheme. This shouldn't be available where there's a materially different rateable value because it's contemplating springing back to what was before and that being essentially the same. And it follows from that it's inherent in a monk case, because what's happening in a monk case is stripping back in order to carry out works undergoing refurbishment. That one would ordinarily anticipate that there would be the type of change that would make this a ABC case rather than an ABA case. Now, my Lord can test that at the margins with the gold wallpaper point, and I accept there'd be some hard cases as to whether that broad proposition fitted, but my schematic answer is this is not a power intended to provide the remedy that's sought of it in a monk case, and certainly not in this monk case, where we know that the footprint changed, we know that the footprint went down through the demolition of those office buildings, and that one, unsurprisingly, that led to a lower rateable value from the output of the scheme of works. So I say primarily in my respondent's notice case that Mr. Wilcox's submission should be applied to the perhaps stronger facts of Great Bear to say that Regulation 38.7 is not applicable in the circumstances of Great Bear. I don't rest, if it helps to have this discussion briefly, I don't rest on the nature of the deletion proposal as opposed to the Supreme Court compromise. I say it's clearer in the deletion proposal, but I think, in common with all of what my learned friends have said, I would invite the court not to read Monk in the Supreme Court as ruling out the deletion approach. It's actually the logical implications of their analysis, but they were saying there may be some they were being told there may be some inconvenience to this. There is a method that potentially keeps this on the valuation officer's radar better, and then I think there was also an issue in terms of a process that my lords aren't troubled with, but completion notices, where it was thought that there could be a difference, whether it's in the list or whether it needs to come into the list. So there was a pragmatic acceptance that the substance of this could work without deletion, but the substance of the analysis does support deletion. That's the upshot of the Supreme Court. There's nothing in the Upper Tribunal decision in Canary Wharf that contradicts that. Both approaches are permissible, and we've heard where the current practice is, although that's probably irrelevant to the legal point.
Mr. Klinsky, have I correctly understood your argument to proceed in 3 stages? Firstly, sub-regulation 7 does not apply in what we've been calling a monk case. Alternatively, secondly, if it applies in all cases, it should never be used in a monk case. And thirdly, which I think you're going to come on to, if it can be used in a monk case, then the way in which the tribunals exercised their discretion in this case was correct.
My lord, that is the shape of the argument. Yes, I'm very grateful for the assistance in formulating it in that way. May I just briefly address a topic that's featured in the exchanges with the court and the advocates of accuracy and inaccuracy, and offer these observations. I say at the moment, and in common, I think, with the observations of my learned friend, there's probably many a different scenario contemplated under the heading of accuracy or inaccuracy. So may I offer 3 distinctions? So the first one is the accuracy achieved by giving effect to a proposal that's made. So that accuracy is the furtherance of the statutory scheme on any view. And here, that accuracy begins and ends when the hereditament is taken out of the list with effect from the 23rd of June 2014. The second type of inaccuracy would be inaccuracy that's a consequence of limitation periods in the statutory scheme. And again, that is the operation and furtherance of the statutory scheme. It's not inconsistent with the statutory scheme, it's the application of the statutory scheme. It's an imperfect statutory scheme, but it has limitation periods, it has expectations for actions. If they're not met, certain consequences may follow in furtherance of the scheme. And then we have the third type of inaccuracy, which is the inaccuracy that's at issue on my case, in this case, which would be inaccuracy arising from a positive determination to keep something in the list or put it in the list. The point arises in both scenarios, knowing that it's inaccurate and it can't be challenged. And that is, I say, not a step that's in accordance with the statutory scheme, and it's fundamentally inconsistent with the features of the statutory scheme, which I emphasise to the court.
I understand you say it can't be challenged because of 4.3c.
Yes.
But the ratepayer is a participant in the VTE proceedings.
Yes.
So in what sense can't be challenged? I appreciate it can't be challenged by the making of a proposal, but if there's already been a decision of the VTE. But why is the ratepayer not able to challenge it full-bloodedly in the VTE?
Because it's beyond the scope of the proposal, the leader properties. The proposal isn't concerned with the rateable value, the proposal is only concerned with should there be an entry in the rating list.
But in considering when arguing about the exercise of discretion,
yes,
all of these arguments can be piled in at that point, and the tribunal will then reach an appropriate conclusion.
My lord, I agree, and that's certainly my case if we get to stage 3 of my lord's formulation. But my case in relation to stage 1 and stage 2 is that understanding the scheme, you never reach that point.
Yes, I see.
And so, my lord, also just focusing in on that point, insofar as numbers assist. Now, if it would help to have exact numbers, we might need to do some agreement behind the scenes. But my learned friend offered some ballpark numbers. They're agreed as ballpark numbers. The instructions I got were slightly different figures, but I don't think I want to take time trying to offer precise figures. But if the court wants them, we can see what can be agreed and produce a note to give them. But they're of the order of magnitude of 90,000 in terms of the difference, the overtaxation from a proper implementation scheme, and it said 900,000 in terms of the quote windfall. Now, of that 900,000, obviously, 80% of it is those last 2 years, because it's a 2.5 year period in essence. So 80% of that figure is the whole period from the 1st of April 2015 to the 31st of March 2017, where the VO had a whole year post-Monk. So I say that's on any view, a very different category of there was an obvious step that could have been taken. That is, I say, that portion is on any sensible view a straight limitation position. That's a loss that flows from a inexplicable and unexplained lack of action on the part of the valuation officer. So, I mean, I don't concede the position in relation to the other 20%, but it's much starker, and that is what was troubling the tribunal below. The size of this and the lack of an explanation for action, and obviously the only explanation for action that's been put forward is, well, both sides could have taken action. Well, I don't accept that for the reasons that I do accept they could have done, but I don't accept that's symmetrical, if you like. There's a massive asymmetry there because there's a statutory duty on the part of the valuation officer, and there's a clear lack of a need to do so for the reasons I've submission, because if the scheme runs its course, there'll be a subsequent opportunity to challenge at the point of entry in the list. So, my lords, I'm going to go to the discretion argument so that I can leave time to finish.
So just to see what the decision was, it was declining to order the restoration of the hereditament to the list. Is the substance of the UT decision?
Yes.
And indeed.
Yes.
Below. That means, and you may be right, that depending upon which point in the existence of a list, 5, 6, 7 year list, that inaction on behalf of both parties may lead to effectively a valuable commercial premises having not appearing in the list throughout the entire period of the list, or almost the entire period.
It does happen. I mean, I don't accept the formulation of inactivity on part of both parties, because my case is
asymmetrical inactivity on behalf of both, if you prefer.
Well, my lord, I don't want to push the point, but what I would actually prefer is justified inactivity on the part of the ratepayer and unjustified activity on the part of the valuation officer. But my lord, that's the scheme. It might be thought a rather bizarre scheme that so much turns on entry in the list. So if we contemplate a scenario where there's a property beneficially occupied, but it stays below the radar for the whole 7 years of the valuation office through complete oversight or incompetence, then it would be in accordance with the statutory scheme for no rates to be paid on that. And there wouldn't be any, on the current scheme, there wouldn't be any wrongdoing or actionable criticism of the putative ratepayer who didn't report that.
Well, in accordance with the statute, with your interpretation of the statutory scheme, which means that sub 7 can't be used in such circumstances.
Well, my scenario isn't a sub
Yes.
reg 7, but in answer to my lord, yes, because it subverts the division of role. My submission is it subverts the division of roles in the scheme, and my lord's understandably puzzled by some of those divisions of roles and the hard-edged nature of it, but I unapologetically submit that's the scheme. So my lord, may I move to discretion? The court may not have in mind that when the learned deputy judge granted permission in this matter, he made some observations in relation to the differences between the case, which are at page 71 of the bundle. Now, there may be an abstract point of law as to whether that's part of the decision, and it may not be, but in terms of understanding why there's a difference between the two decisions, the learned judge, the learned deputy president offers some observations on page 71 in relation to that, and the part that's relevant for the purpose of my submissions, I just wanted the court to have this factually in mind, was the emphasis on the difficulties being, in this case, being of the valuation officer's own making, and I think that my submission is that obviously is a fair observation, certainly in relation to the period from the 1st of April 2015 to the 31st of March 2017. So it's the same. It's not quite the same tribunal. The deputy president was common to both. Mr. McRae, the member, was brought in for this. I do. It's not necessarily part of my case, but my Lord Justice Arnold's observation that there may have been a feeling that the point, as expressed on the facts of Avison Young, where the point wasn't really argued on discretion and the difference was very much de minimis on one hand and very substantial on the other, that Avison Young may not be the end point of the analysis, and the deputy president obviously knew what he decided in Avison Young, treated this case differently, and explained himself, in this document at least, of doing it because he regarded the facts as materially different in Great Bear.
Well, the difference that he saw was that the difficulty was of the VO's own making.
Yes.
Well, wasn't that the case in both cases?
Well, that might be right. I mean, it was much starker in my case because of that, because of the period. I mean, on my primary submission, it is common to both cases, but they're very stark in my case because of the 2 years. So in Avison Young, which there isn't an appeal on discretion, but he ventures the opinion in Avison Young that, if you like, it's legitimate to do this balance of prejudice. Now, my submission is that the court should be really careful about that because there's the world of difference between an unjustified imposition of taxation, which is the leaving it in the list at the wrong value scenario, and the state missing an opportunity to tax, which on my case, I appreciate not on every analysis the court has heard, but on my case is how this case should be contemplated. So I can deal with the discretion. I mean, in terms of approach to discretion, just before I get into the grounds briefly, in terms of approach to discretion, I don't dissent from the way my learned friend put it, that it's a de novo hearing.
But is that right? Because since we had that debate, I've refreshed my memory of what was said by the Upper Tribunal on this point in the Avison Young decision.
Yep.
And I'd be grateful for your assistance, because if you look at the Avison Young decision, the relevant paragraph is paragraph 38.
Yep.
He doesn't decide the matter, as he makes clear, but what he says is that he's disposed to think that the approach to discretion under Regulation 38.7 should be to review and not rehear.
Yeah, my lord, that's certainly right, and I was going to draw that to the court's attention. He did express that as a tentative view. I don't believe there was, I mean, it's apparent from the decision that the discretion point came in, I believe, in my learned friend's Mr. Wilcox's oral submission, so it wasn't a developed point in Avison Young, which is probably why it doesn't feature in the appeal. He expresses that view. He does it by analogy to the position in relation to case management. As my recollection was that when the matter was when Great Bear was argued, neither myself nor Mr. Dommel were supporting that approach. We were both contemplating it on the basis that the tribunal, that wasn't a particularly sustainable analysis because this went to substantive entitlement rather than being truly analogous to case management. But my lord's absolutely right that was the view he expressed. He doesn't repeat that view in Great Bear. He must be taken to have had it in mind, and although
I think the short answer, I believe, correct me if I'm wrong, is that this is simply not a point that arises because the deputy president didn't decide this question in Avison Young, and it doesn't arise in this court, not least because in both cases, both tribunals exercise their discretion in the same way. So It's academic.
OSC, yes, I think is. My lord, it's probably me, but I haven't quite followed that. In Avison Young, no, I understand the point. So they both tribunals went the same way. I understand.
In each case, the outcome were opposite in the two cases.
Yes, but there was
in
always
each case,
consistency.
both tribunals exercised their discretion in the same way.
Yes. No, my lord, that's spot on. I understand the point. The only jurisprudential observation I can make to try and help on this is just to call attention to what the Supreme Court said in paragraph 4 of the Cardtronics case. It doesn't go to discretion, but I would submit that it goes sort of a fortiori to discretion. So that's the last tab 22. Cardtronics was about cash machines, and it was a test case on how the rating treatment of cash machines. And Lord Carnworth gave the judgment to the Supreme Court. And at paragraph 4, he just makes some observations about the appellate system, and he notes there that the Upper Tribunal is a full hearing, not simply a review. And he does that by reference to Johnson and HB Foods, which probably isn't the case that my lord had in mind, but I believe that that's been cited and discussed in some Court of Appeal cases, possibly such as Ludgate House as a recent case. But there is an authoritative decision that it is a full hearing.
I think it was this paragraph 4 of Cardtronics which I had in mind, with the reference to Johnson, which is, I don't remember having looked at, but I mean, I'm sure what is said about it is correct.
So the scheme is, it's an expert tribunal. The VTE isn't always an expert, as it happens. Mr. Young is a full-time, actually I don't think he's a full-time, but he's the vice president, so he's an experienced member of the Valuation Tribunal. But generally speaking, the approach of the Upper Tribunal, unless there's something exceptional about the nature of this particular power, would be de novo. And the court has emphasised here deference to that expertise. So I call attention to both elements of those.
But we are hearing, essentially, in this particular corner of the case, an appeal from the exercise of the discretion of the Upper Tribunal.
Correct. And I submit
That's where we get to.
this tells you that you should give deference to their expertise. Obviously, I'm not pushing that too far if there's a material error, but it is part of the context. And I do say, therefore, that you should approach it as if the Deputy President had in mind the approach he'd taken in Avison Young and saw this as a materially different case, even if he expressed himself somewhat shortly in terms of articulating the precise basis of that.
And so far as concerns the appeal to this court, that lies only on the point of law.
Yes.
So we have to diagnose an error of law before we can do anything.
Yes. So in terms of discretion, it has to be out with reasonable.
I mean the usual.
Yeah. So obviously my response in those cases doesn't arise, and then of the grounds that are relied on, the first, essentially I think 3 of them were emphasised more than others. So if I could just give you the heads up on that, I've tried to deal with them in my skeleton. But the first one is the allegation that the tribunal failed to take account of the absence of an entry in the rating list. Well, in my submission, that it's inconceivable that they didn't have that in mind. That was what they thought was decisive in the particular circumstances of Avison Young. They clearly realised there was an extended period where it wouldn't be, but they explained the culpability on the part of the valuation officer as, in their judgment, the decisive criteria. So the allegation that there's a failure to even take that into account in my submission can't get off the ground, and I would respectfully say that the court should approach it on the basis of the weight to be attached to that. If we reach that stage of the argument, is a matter where great deference should be given to the expertise of the specialist tribunal. The second point is impermissibility in terms of looking at the rateable value. I respectfully say that must be a bad point. I adopt the exchange I had with my Lord Justice Peter Jackson. I note my learned friend didn't push that point too far, and I also asked the court to note the whole basis on which it was argued before the tribunal by the valuation officer was not only should they take it into account, but they should actually alter to the lower level. So it was abundantly clear that the differential for rateable value featured in the way the case was put, and there's no error in relation to that. The third point is the reinstatement point, as opposed to it remaining in the list. Now, my submission is in substance, the position is it was out of the list and it has to come back in the list if the tribunal exercises its discretion. And it's worth thinking about what would actually happen if the tribunal exercised its discretion, because it wouldn't make it, the order it would make would be that the valuation officer should amend the list. Now, how would the valuation officer amend the list? Wouldn't insert a footnote, this is in the list, but it was out of the list between these two dates. My submission is, in practical terms, the entries would be removed from the list for these dates, back in at this. So in substance, it would be a re-entry.
Well, can I ask about that again? Because we discussed this a little earlier. I'm still not entirely clear what your answer is. And let me try and rephrase, because I think it's my fault. I didn't make myself sufficiently clear. What I was trying to suggest is that conceptually, there is a different list for every day. This is a daily tax. So conceptually, for 365 days of the year, you have 365 lists. And therefore, the fact that an entry is deleted on one of those days doesn't in and of itself tell you anything about what happens on the succeeding day, because that's a new list. So conceptually, I would like to understand what your answer to that is.
Well, my lord, my answer to that, I just want to go back to look at section 41 and 42 again. So I don't want to sort of tread on, dance on, make distinctions that aren't helpful, but I don't think I can accept the premise of the question that conceptually there is a new list for every day. The statutory basis talks about there being a rating list for the period of a rating list, which is defined by the statute. It's a 5-year list, but in this case it's a 7-year list, because it can be extended by regulation. And what that list has to show is hereditament for any given day where the statutory criteria are satisfied and with a rateable value. So the list necessarily conflates periods of time. So there wouldn't be 365 entries for 2021. There would be one entry. If I used the period in case, there'd be one list for the whole period, 1st of April 2010 to, as it happens, the 31st of March 2017. And that list would show all the hereditaments, and it would differentiate between periods. So what one would actually have is a sequential series of entries, and one would look at the effective dates of those entries. So in substance, the effective date ending the 3rd of October is there is nothing in the list. And in substance, on the 4th of October 2014, if there was the power to do it, there should be a hereditament in the list with a rateable value, but then it would remain unless and until there was some other challenge to it. So my whole case is that my proposal put in issue the whole of the position from the date of the proposal because it was a deletion and it required some kind of response at the reinstatement point. So I do say in substance, if given that's well founded, given then in substance there's no hereditament in the list, in substance it's being put back in.
Will another way of answering my lord's question be to say that rates are a daily tax in the sense that they are imposed on a daily basis, but by reference to a list which is compiled for a 5-year period?
My lord, yes. And my lord, yes, subject to the provisions within the statutory scheme which regulate the manner in which that list can be altered.
Yes, of course.
So, but yes, subject to that. My lord, yes.
But section 42, for example, subsection 2,
yes,
In fact, it's subsection 1, subsection 2, subsection 3, subsection 4. They all each say for each day.
Yes.
Yes, but that would be reflected by periods. So it would be from. It would usually be from. So this is compiled list entry, and then the rateable value is reduced to this date. This is the material date. This is the effective date of that change. And so you would look, and there would be one entry in substance for every day, assuming the hereditament was in the list. If it wasn't in the list, for the day, it wouldn't meet those statutory criteria, and rates wouldn't arise. Because when we go to section 43, the statutory question of is it in the list is asked on a day-by-day basis.
I mean, that is the charging section, isn't it? So that's where you actually find the charge for the liability.
Yes.
And since that's imposed on a daily basis, then the list has to be capable of answering the question in relation to any given day.
Yes, that's undoubtedly the case. Yeah, and I mean the heading to regulation 14 is the time from which alterations are to have effect. So it's limiting. What one needs to always ask is, what's the relevant period to which this applies? And again, I'll repeat myself. My submission is in relation to the particular proposal. It put in issue the entry from the date of June, and it required a response to go back. So, my Lord, my point here is that there's no plausible basis for suggesting that the Upper Tribunal misunderstood what was at issue, and that the ground of appeal is parasitic upon the terminology of restore. My submission is that terminology is entirely apt, but even if my lords are troubled by the terminology per se, it is merely terminology. The tribunal plainly understood the dynamics of whether there was a justification on the conceded basis that there was no justification pursuant to the proposal of having this actively in the rating list, and that was the substance of what they were grappling with.
If there's time, could I just ask you about the electronic proposal, which appears at our bundle at tab 11,
Yes.
page 100 and page 100.
Yes.
This is your client's proposal lodged on the 2nd of February 2015, by which time the premises were back in beneficial occupation since October, is that right? Sorry, I'll give you a moment.
No, I'm there. Sorry,
You have it.
I'm there. Sorry.
Just pulling back to mind the sequence of events.
Yes.
It's June till October 2014 that the premises are out of action.
Yes.
And in February 2015, we have here the proposal to deal with that.
Yes.
And at box 15, it's again the E thing, is the property has been demolished or no longer exists. Well, we've already covered the fact there's maybe a drop-down menu.
Yeah.
But which of those was accurate?
Well, that the question is asked in relation to the date of the proposed alteration. So
in June.
Yeah, I mean, there was some discussion. There was the Upper Tribunal grappled with this in its decision, and the view that it took, which was common ground, was that reading it together with box 16, it was saying it was incapable of beneficial occupational grounds
Right.
building.
Well, it was really box 16 that I wanted to ask you about.
Yes.
That the request was, as a result of building works, the assessment should be deleted with effect from the 16th of June 2014.
Yes.
But this is speaking in February 2015, by which time the premises had now been operational again.
Yes.
For a period of 4 or 5 months. And so, to what extent is it relevant to consider whether the proposal is actually accurate?
Well,
because really what the proposal, it wasn't that the building's been demolished, no longer exists, and therefore it should be deleted from the 16th of June forever.
Yeah. Well, the
The proposal was actually that you shouldn't be paying rates during the time when you couldn't beneficially occupy it.
Well, my lord, no. The proposal was nothing to do with the payment of rates. Payment of rates is parasitic upon the list amendment. So the proposal was take it out of the list with effect from the 16th of June 2014, because it should be deleted due to building works.
Yes, I understand that, but Part C, which is grounds for your proposed alteration, doesn't reflect the reality. It's a proposal which simply does not reflect the reality, which is that there was a temporary cessation of occupation for perfectly understandable reasons, and then you were back and up and running again. You appear to be building your entire edifice on a misdescription of what was actually taking place here, which was not a demolition from June forever. It was a temporary inability to occupy.
Well, my lord, the expert tribunal below grappled with that and sought submissions in relation to that, and made a determination in relation to that. And I'll just remind myself of so paragraph 6 is where they discuss that, and they record at paragraph 6, page 60 of the bundle. It is common grounds, however, that the proposal sought only the deletion of the hereditament. The statement that the property had been demolished was not correct, since only part of it had been, but it's common ground that the building was not capable of beneficial occupation whilst the works were carried out,
Yes.
and the material day ought to be the 23rd of June 2014 when they commenced. So,
I'm not I quite accept that.
Yeah.
But the point is, essentially, you've made a proposal which contains the start date, but does not contain the stop date of the beneficial occupation. So, if you're putting forward a proposal, surely the proposal ought to reflect the reality of the situation.
well, my submission is that the proposal has to reflect a statutory ground. The statutory ground is the hereditament should not be in the list, and they're saying it should not be in the list from the 16th. Now,
But you are not saying the hereditament should not be in the list forever.
But the point is that you make a proposal and then there is a determination by the valuation officer pursuant to that proposal. The point my lord is putting to me is the point that wasn't part of the tribunal's finding and isn't advanced by the valuation officer, that in the particular circumstances of this proposal, you could reinstate the hereditament in the rating list pursuant to the proposal. That is the whole. We're only in this appeal because the valuation officer doesn't take that view, and my submission is they're right not to take that view, because properly construed, this proposal took issue with the existence of the hereditament on the 16th of
Right.
June.
So it doesn't matter how exorbitant the proposal is, how detached from reality it is. That again, you say, is part of Parliament's intention in the scheme that.
No, it could matter, because there's provisions under the statutory scheme for there to be challenges to the validity of the proposal. The tribunal has to take a view on the objective meaning of the proposal, but in the circumstances that we're in this appeal, I submit, as I'm entitled to do, that the expert tribunal has looked at that quite carefully, has formed a view as to what the proposal means, and it's not the subject of appeal, and it was common ground below, and that's not an issue that is before this court. The basis in the statement of common ground that's also in the bundle is this is the effect of the proposal. I accept the proposal certainly could have been drafted in a clearer way, but there are thresholds within the scheme, and we've passed those thresholds, and the legal issue in this case is what are the consequences of the proposal on the footing that it proposed deletion from that date.
Thank you.
My lords, I obviously fully appreciate I need to finish. Can I just I haven't dealt with ground 4. Ground 4 is the ratepayer could protect itself provision. I hope from my skeleton and from my exchanges with the court knows my submissions in relation to that. And then the ground 5 is that it would empty it of its purpose. And again, I pray and aid the provision I drew attention to the embargo on altering the rateable value subsequent to that. And I give the road closure example, and I say there was ample purpose for this provision if it's constrained in the way that I've proposed. And if the discretion arises, it should be approached in a way that is sensitive to the impacts of, and I adopt what my learned friend said in his reply, of but for this provision there wouldn't be an entry, and therefore one has to think about the impact of this, and that it isn't right that my case requires the tribunal to strip out the inaccuracy of the result, coupled with the inability to change, is a strong feature of this case. It isn't a feature of many other cases where the rateable value is the same. For example, the roadworks case. So again, there's no legal error, I say, in ground 5. My lords, I appreciate I've overstayed my welcome. But
well, we've been asking you a lot of questions, Mr. Walensky, so I certainly wouldn't criticise you for that.
very grateful. Can I assist further?
Anything else? No, thank you very much.
My lord, mindful of the time, I have 5 brief points of reply, which I would hope I could do in 5 or 10 minutes.
Certainly, well, we're not going to stop you if the moment the clock strikes 1.
I'm very grateful. The first point, the submission of my learned friend that the scheme is for the VO to lead and the ratepayer to answer. One only has to look at regulation 4 and the provisions enabling the ratepayer to make proposals where there is, for example, a material change of circumstances, to see that that is not always right. Second, the suggestion that if the discretion was exercised, the ratepayer would have no right of response. The problem that the ratepayer has is the valuation in the list at 825,000 from the 4th of October. The ratepayer has had an opportunity to challenge that since the 4th of October 2014. The determination, the exercise of this power would not remove the ratepayer's ability to challenge it, because they had the ability formally. What in effect is the problem if the discretion is exercised is that the ratepayer, by virtue of the limitation provisions, isn't any longer able to make the proposal. So it's simply not right that the exercise of discretion would take away the ability to challenge. And the premise is a wrong one, which is effectively that the 825,000 on the list as of the 4th of October only arises after the exercise of the discretion. And we see the proposal on the face of it says 825,000. I mean, they know what it was at the time of the proposal in February. The related point, thirdly, is that when my learned friend talks about inaccuracies which are the consequence of limitation periods, that cuts both ways. And it applies to the ratepayer too. The inaccuracy, to repeat the point, at issue here is the 825,000 on the 4th of October, and that the ratepayer knew was the position in the list from that date. And if it's unable to address that, if the discretion was exercised, then that is, as my own friends, just the application of the scheme. Fourth, just briefly to try and engage with the point Lord Justice Arnold made in respect of the daily nature of the list. And I'd respectfully agree with the plain provisions in section 42, that in effect it is a list which must show provisions daily. And one way of looking at what the tribunal does on an application for an alteration is that it makes it states that this alteration is made and the date from which it is to be made. But unless the tribunal says more, that alteration is implied and treated by the valuation officer as affecting every day subsequently in the list. So in effect, the choice for the tribunal in this case is not, shall we delete the entry on the day, the 23rd of June? It's, shall we delete the entry with effect from the 23rd of June and thereafter, without limitation? Or shall we limit the effect of that change? And so I repeat the point that I think my learned friend didn't accept, but which I say is conceptually correct, that this hereditament, at the point that the Valuation Tribunal is considering the discretion, is on the list as at the 4th of October 2014. And it is not in consequence of the exercise of the discretion that it is on the list. It is in consequence that it remains on the list. And fifthly and finally, my learned friend took you to the point made in granting permission made by the Deputy President, the grounds of distinction being that the difficulty was of his own making. And my learned friend fairly accepted that the absence of an alteration was something that could equally well have applied to Avison Young. In support of the Upper Tribunal's considerations, my learned friend pressed very hard at the point that from the Monk decision of the Supreme Court on the 1st of March 2017, up until the point at which the valuation officer could no longer make alterations just over a year later, it should have acted and didn't. And as to that, I would respectfully urge a degree of realism and caution. The valuation officer is not omnipotent. And I referred in my skeleton to the case of Chorus, and the same point arises in a slightly different formulation in Baird. But there were a number of cases about basically complaining of unlawful delay, and these were judicial review proceedings, unlawful delay on the behalf of the valuation officer in making alterations. And that was the basis on which I cited the passage in the skeleton, and it is at divider 8 and paragraph 47. That duty to maintain an accurate list has to be discharged in the real world where there are finite resources and only 24 hours in the evaluation officer's day. Now, obviously, the situation in that case was a judicial review, and it was a complaint of an unfair delay in taking action. But what I would say is the same tenor must also inform the tribunal's consideration of what it could realistically expect the valuation officer to do in what time. At the very least, what the court is observing in that case in chorus is there's no assumption that that any delay in taking action is somehow unlawful, or that the statutory scheme assumes somehow a perfect omnipotent action on behalf of the valuation officer. Those are my 5 points in response, unless I can assist further.
Good. Thank you very much indeed, Mr. Donwall. Good. Well, many thanks to all counsel for keeping within pretty much the time limits which we have to keep within, and for your very helpful arguments. We will obviously take time to consider our decisions and let you have our judgments in draft in the usual way, inviting corrections of typographical and other obvious errors, but not re-argument of the substantive matters. And we hope you will be able to agree consequential matters between yourselves. If not, we will ask in the usual way for brief written submissions, and we will deal with the points on paper. Hand down will probably be virtual, but may, if matters continue to go well, be in court, but either way we will keep you informed, and there will be no need for attendance when hand down does take place, whatever form it takes. So thank you all very much, and I should have said to your respective teams for the arguments we've had the benefit of listening to over the last day and a half. So that concludes the hearing. Thank you very much.